The deliberative process privilege, I kind of view it as the kudzu on the FOI landscape. For those of you who have never driven through the highways of North Mississippi and seen the kudzu vine, let me tell you, it takes over every other piece of vegetation on the landscape. And when you think about the deliberative process privilege, that's really what, in its broadest form, it can do to the standard arguments that we have always put forth on the state level for access to information. Not only should we be entitled to the decision or the policy, but the underlying reasons for that policy, the persons who contributed toward that decision. You have people who are paid with taxpayers' money to make this kind of advice, plus you often have outside consultants who are hired to make recommendations on what the courts, some of the federal courts particularly, have termed pre-decisional advice. And when you have a very broad, ill-defined deliberative process exemption, you shield this information. Plus, we also want to know what other persons participate in the process. What lobbying groups, what campaign contributors. And if you're not careful with this privilege, it can absolutely cut off access to everything that is, as they say, pre-decisional. I want to read you the deliberative process privilege that the Louisiana governor has. And I want you to think about how broad this is. Find it. Well, where is my process? You got it here? I got it here. All right. The statute gives the governor a privilege relating to the deliberative process of the governor, and it defines that as records relating to the deliberative process of the governor are all forms of pre-decisional advice, opinions, deliberations, or recommendations made for the purpose of assisting the governor in the usual course of the duties and business of the office. So you can see right off the bat what a broad, ill-defined privilege this is. It hasn't been acted on by the courts, and I'm going to leave it to Terry to talk more about the problems that can cause. I wanted to go over the Justice Department's guidelines. The words themselves are not included in Exemption 5, but the privilege has been read into Exemption 5. And its general purpose, according to the federal courts who have interpreted, is to prevent injury to the quality of agency discussions. And they cite 3 policy purposes: to encourage open, frank discussions on matter of policy between subordinates and superiors, to protect against premature disclosure of proposed policies before they are actually adopted, and 3, to protect against public confusion that might result from disclosure of reasons and rationales that were not, in fact, ultimately grounds for the agency's adoption. So that raises several questions, which I hope that our panelists will discuss, and also we want to invite participation from the audience on these points. But let me ask you right now, how many of you have been confronted with a deliberative process claim?
Over here, Linda, too.
Okay. Of those of you, I can't see past the road. Of those of you who have, how many of you were ultimately unsuccessful in obtaining your records?
Over here, too.
All right. Okay. Well, those of you who have not had to deal with this, beware, because it will come your way. As you know, these things have a way to jump from state to state. And I think yesterday afternoon, the representative from Oklahoma commented that his governor has recently claimed this privilege. And these are the things I think we want to address and think about. What information, if any, should be covered by such a privilege? Is there increasing local and state government reliance on this privilege? And if so, are they going to look to some of the federal litigation, which is really quite bad from our perspective? Is there a tendency to confuse the deliberative process privilege with executive privilege? How do they differ? And I think Mike might have some views that he's going to share with us on that. How can FOIA advocates limit the reach of this privilege? And what about this argument that advisors are going to be chilled if ultimately their advice is made public? Is this a legitimate concern or a speculative concern? And what about this last notion? I heard some giggles from the audience that pre-decisional disclosure can result in public confusion. So I'm going to now turn to Michael Wrights and ask him to give us his views on this and address some of these points that I've raised.
Thanks, Linda. And I'm going to stand up so I can see this side of the room. I've already had enough of that side of the room. My name is Mike Wrights. I'm with the Mackinac Center in Michigan, but prior to moving to Michigan last year, I worked as an attorney for a think tank in Washington State and had the opportunity to deal with a lot of open government issues. I want to say thank you to Ken and to NFOIC, not only for holding this conference, but for everything that you do to make the work of state groups possible. You direct a lot of critical resources around the country, and that's essential to what I do and what many in this room do as well. And it's also especially meaningful to be here, and I'm not going to steal your thunder, Ken, but to see Brian Sontag honored this year is a great privilege. He's a friend of mine, and I can't think of anyone that's more deserving of that award. Brian and I spent a lot of time on the road together last year doing community forums around the state of Washington, telling people how to deal with open government issues and problems. And so we had a lot of time spent with just normal people. And he's also a person, he held state office for many, many years. I never saw him turn a speech down, and he showed up at a lot of speeches. And he always said, I'm paid by the taxpayers, I work for the people, and if the people want me to show up somewhere, I think it's appropriate for me to show up. So that's the kind of attitude that Brian has, and I think it's really good that we're able to honor him. If anyone has a line on Drew, I think he just popped out, but I had a couple of slides I wanted to show you just to get things started here.
Yeah, I think you looked at the screen and said, oh shit, so we went out.
Yeah. Drew, I'm ready for you there. Yeah. So this is just, you know, it's morning. If you're like me, and this is my first time in New Orleans, I had to experience the city a little bit, so I didn't get as much sleep as I should have. I wanted to show you a couple of open government trophies. And what I mean by that is, you know, fishermen get together and they talk about the fish that they caught or that they didn't catch. And when divorce lawyers get together, I'm sure they talk about their worst clients. And what do we do when we get together? We talk about the worst stories we can imagine. And so I wanted to share a couple of those with you. All right, I'm gonna talk about, sorry, so thanks for indulging me there. I'll show you my trophies later. I'm going to talk about executive privilege, which is similar to deliberative process privilege. They're in the same family. I guess they're kissing cousins. And all the things that I say about executive privilege are interchangeable with deliberative process. And I've got a couple of lessons that I think you can apply in your own states and with your own problems. I'm going to tell you a story about 3 governors in Washington. The first governor is Governor Gary. And Governor Gary was elected in the 90s and was a good governor. And on open government issues, he wasn't necessarily a champion, but he didn't do a whole lot of damage. But one of the things that we saw with Governor Gary is that he started asserting this idea of executive privilege as a basis for withholding public records from the public. And not very often, but every once in a while, you would see that pop up with Governor Gary. Now, the problem with executive privilege in Washington State is that It doesn't exist in statute or in the Constitution. The public records law says if you're going to withhold a record, you have to cite a statutory exemption, and executive privilege is not one of those. So we had this phantom exemption that sprung up with Governor Gary. Second governor is Governor Christine, or Chris, as most of us called her. And Governor Chris administered an explosion of executive privilege assertions in the governor's office while she served her 2 terms. Now, I have a lot of admiration for her and some of the challenges that she had, taking the state through the recession and all those issues. But on the issue of executive privilege, we clashed frequently. My clients, the think tank that I worked for, did a study of executive privilege and the number of times the governor's office asserted it, and we found that over a 4-year period, she asserted this phantom privilege 500 times. Only twice did the requester say, I don't think that's a real exemption, and then the governor would give over the documents and waive the exemption. I was one of those times. But if you think about all the other people who were turned away by a constitutional theory that really wasn't embodied in state law, it was really disheartening. So because of that, in 2011, the think tank that I worked for sued the governor, Governor Chris Gregoire, and we challenged her use of executive privilege, which is very similar to deliberative process. Sadly, at trial court, we got a horrific ruling. Not only did the trial court say, now this is in Thurston County, which is Olympia, which is the seat of government, and you know how the judges tend to rule in the seat of government. But the judge said, not only do we recognize that executive privilege exists as an inherent power that the governor can claim based on separation of powers, but she applied it in such a way that it made that exemption a super exemption, one that was an exemption on steroids, if you will. The public records law in Washington says that the presumption is that all records are public unless an exemption applies. Well, the judge said, no, not for executive privilege. If the governor claims executive privilege, it's automatically sealed. The PRA, the Public Records Act in Washington also says that there's a burden on the agency. If they want to withhold a record, they have to prove that it's exempt. That's similar in many states. Not so with executive privilege, said the judge. The judge said if you're going to have executive privilege applied to a document, it's presumed to be privileged, and the burden shifts to the requester, and the requester has to overcome that privilege. Not only that, but the law says that when you request a document, the agency can't ask who is asking for it or why they want it. Judge Murphy said when it comes to executive privilege, the requester has to show a special, individualized interest in the document in order to obtain that document. And we looked at a number of other states that have a similar requirement, and it's almost impossible to overcome that burden. The last problem with Judge Murphy's ruling was that, now I was the lawyer in this case, so maybe I'm telling you that I'm incompetent, I don't know. But the last part of the ruling that we had a big problem with, in our state, we have this mechanism where you can request in-camera review, which means the judge can take a document and look at it and see if the privilege or exemption applies. And we requested in-camera review of the documents that Governor Gregoire had withheld. And the governor argued, and the judge agreed, that it would be a violation of the governor's executive powers for the judge to look at her documents, and separation of powers compelled the judge to not look at those records, and in fact would not be able to look at them at any point in the litigation. So we had a problem with that ruling. We appealed to the state Supreme Court, and the court agreed to take direct review from the trial court, which is extremely rare. And arguments were last September, and we don't yet have a ruling, and I assume next time we get together, we'll be sharing with you the results of that. We're confident in our chances, although any lawyer in this room will tell you there's no sure thing in litigation. But the benefit of that particular effort is that we got quite a bit of media attention on this issue. It was reported at every stage of the litigation. Every major newspaper in the state editorialized in favor of our position, and in fact, several of them editorialized 3 or 4 times, and there was nothing that supported the governor's position when it came to withholding these records. Thanks. I'll just stick it right there.
I'll operate it over.
The problem, of course, was, we got the bad ruling, so that helped fuel some of the media. We also got a broad coalition of groups working together on the issue. NFOIC filed an amicus brief. SPHA sent some money our way to work on these issues. We had the ACLU file an amicus brief, the Institute for Justice, which is a libertarian group. Our group was a fiscal conservative group. So we had a wide array of folks working on this, ACLU. And that had important bearing on the next governor that I'm going to tell you about, and that's Governor Jay. Governor Jay Inslee was elected in 2012, took office in January. So Governor Gregoire's term finished out. Governor Jay took over. And we had what we thought was an opportunity, even with this litigation. And a very smart reporter in Olympia had a good idea, and I'm not saying it was because he talked to me, but he had an idea to ask the candidates who were running for the governor's office about this issue of executive privilege. So it was the perfect collision of timing where we had arguments at the Supreme Court while the gubernatorial election was happening. So these two candidates running to take Gregoire's place, you had the Attorney General Rob McKenna, the Republican candidate, and Congressman Jay Inslee, the Democrat candidate, both running for office. And so this reporter asked them both on the record, what would your administration do if the opportunity to assert executive privilege came up? And both of them pledged not to use executive privilege. Now, the really amazing thing with that was Rob McKenna, as the state attorney general, was representing Governor Gregoire during the litigation. He was her attorney, and he said, I'm not going to do what she does. And we thought that was pretty interesting. Now, Jay Inslee was elected and took office. And so my clients had another good idea, and I'm not saying it was because they talked to me, but they had the idea of going to Governor Inslee and asking for records that Governor Gregoire had previously withheld on the basis of executive privilege. And not the ones in the litigation, we wanted to leave those ones alone, we didn't want to moot the case, but other records. In fact, some of the records that she was withholding, talking points, memos that were exchanged with legislators, meetings about liquor revenue, meetings about the Seattle Supersonics leaving town, meetings about, or records about tribal gaming issues, just a wide array of issues. So we asked Governor Inslee for those documents, and lo and behold, to our surprise, some politicians keep their campaign promises. Governor Inslee told us not only had he not ever asserted executive privilege in his first 3 months on the job, but he gave every record over to us that we asked for and didn't even waive the privilege, just handed us the documents. Now, that doesn't affect our legal case. We actually do get to have the precedent set forward, but there's an important lesson there that I'll mention. So anyway, 3 governors, Governor Gary, Governor Chris, Governor Jay, and quite a bit of work done to shine a light on this problem of gubernatorial privilege or deliberative process privilege or whatever you want to call it. 3 lessons quickly, and then I'll let Terry talk because I've been up here long enough. When it comes to these types of privileges, I think that the ability to get it in statute over just something that's either common law or inherent in the constitutional powers of an office is preferable. Now, I know we're not in the business of writing new exemptions into the law. That's not what we do. But if you have to have it, I think there is benefit to having it statutory and having it well-defined. Otherwise, it goes to the courts, and what do the courts do? They look to the federal case law, and the federal case law on this issue, as Linda mentioned, is not great. So, statutory over inherent privileges. There are some limitations to the scope of deliberative process or executive privilege, and I'll get into those in the Q&A time. But then the other lesson that I think is transferable to each and every one of your states and efforts is that you can create a climate, a political climate, where even though the law is against you and the case law is against you, and some of the statutory burdens are against you, you can still create a political environment where elected officers do the right thing. We saw that with Governor Inslee. Obviously, we've got this case that still has to be decided, but we found it to be significant that a governor who would have otherwise claimed executive privilege, just like his predecessors, did a 180 and decided not to use that privilege anymore. Thank you.
Thank you, Mike.
Good morning. Can I be heard on the other side of the room? Great. I can see you. I moved up so I can see you. I don't know if I'm on the right or the left. Linda will have to explain that to me. I'm Terry Ryder, and I guess I should say get your biscuits ready, because I'm going to represent a slightly different perspective, although not entirely differently. I want to say that I did represent, as Linda indicated, I did represent 4 Louisiana governors, but after Robert's remarks, I want to tell you I did not at any time represent Governor Edwin Edwards. I worked for, I should say, 4 reform governors in Louisiana, including the current governor for a while. I'm proud of that. But in any case, I want you to understand, I am with you 95% of the time. In Louisiana, we have had for a long time, and I don't remember the exact year, but it's somewhere in the middle of the last century, we've had a very strong public records law. We've kind of had some backsliding moments in recent years, and I'll try to get into that if Linda doesn't rule me out of order before I get to it. But we have a very strong public records law. Pretty much anything is a public record in general, in any form or fashion. Long before there was digital media, that was the law, and hasn't had to be changed as a result. I have a slightly different position, although I agree the so-called deliberative process privilege is overused and I think greatly abused. Having advised 4 governors, I've been in a lot of high-pressure situations with the governors, and I recognize that for the governor to make the best decision on behalf of the citizens, sometimes because of time pressures, the opinions have to be given very, very quickly. You're not always in the same room. Now that we have email, and you probably don't, many of you don't know that there never was email, but now that we have email, there's a record. And my advice has always been to everybody on the governor's staff, when you type it, it's a record, and it's out there, it lives after you. But now that we have email, and because of all the pressures of being in an intense office, an executive branch, and I'm only talking about a governor's office because that's the only experience I have. I'm not talking about all the other agencies. I'm with Linda and her feelings about the other agencies. That's another discussion. But when you have the pressures of office of a governor, the best governor, the most transparent, we'll call him Governor Jay, you wind up in a position where you have to make a decision, and you have to have it make it quickly, and you have to have the best advice you can get in order to make a good decision. So I do believe that the most senior advisors to a governor have to be able to say things quickly and frankly in order for the governor to have the best information available. So I do believe there is room for a limited and deliberative process privilege, executive privilege. I really don't care what you call it either. And in Louisiana, for example, we have the words deliberative process privilege in the statute in one location, and only for the governor's office, but only for the governor. We don't have it anywhere else yet. And we didn't have it until 2009 when this governor advocated for a change. There have been attempts in the legislature for many years to limit the breadth of the prior exemption for the governor, which, when I was in the governor's office, was essentially a blanket exemption for the governor. There were no excuses except for money documents, whatever document there was in the possession of what I'll call the core governor's office that wasn't clear. It was just simply not covered and not a public record. And I have to confess to you right now, I signed many documents declining to reveal information on behalf of the governor as his lawyer, citing that exception. I always thought it was overly broad. In 2009, this governor put forth some changes to it, and that's when we first got the words deliberative process privilege into our law. I'll give the governor and his staff great credit for having changed from a blanket exemption, again, not talking about money records, that was the same before as it is now, to all records in the governor's office are now open to the public. They are public documents. However, they did introduce several, we'll call them exemptions, because I think that's what they are. I like exemption better because it seems to me to be more more profound, and that's what we're talking about. We're not talking about temporary things. Introduced several exemptions into our law. I won't go into all of them, but obviously there are security exemptions, which I presume any governor's office has for the safety of the governor and the governor's family. And most of those should be limited in duration. There may be some that need to be more durable than that. But we're talking now about the so-called deliberative process privilege, which Linda mentioned to you. Again, in Louisiana law, it's only for the governor. But there are also other exemptions in our statute dealing with intra-office communications, and only for the most senior people in the governor's office. That one is more iffy to me, of course. And then beyond that, outside that provision is this new beast which they stuck in there. And Linda really didn't get into that yet. This one is the one that really gets her going, so I'll wake her up.
Well, no, go ahead, Terry, and discuss that. I was leaving that to you. So go
Okay,
ahead.
all right, okay. The second paragraph in the new law, 2009, is, I guess the best term I can describe is abominable. Taking Linda's win from her sale. They introduced the idea that on matters of budget, if you can imagine, remember before '09, there was no provision whatsoever protecting any advice or any information on money or budgets. Wake up my auditor buddy here. Now, in this second paragraph in the governor's statute, we have a 6-month privilege. It's ridiculous. And it's basically advice from any agency head, basically an appointee of a governor outside the governor's office, when they make recommendations to the governor or give advice to the governor on matters concerning the budget, they now have up to a 6-month privilege to decline revealing that information to the media or the public, no matter where it is, quite frankly. Back in the agency, it doesn't matter whether they're the top person in the agency, whether they're the top budget person, or the messenger. If they've got it, that privilege is available. It's absurd. The agencies did just fine for the entire time that the public records law in Louisiana was in effect and didn't need it. But now they have that. And I will say that the whole time I was in the governor's office, primarily with Governor Foster and Governor Blanco, two really good reform governors in general. Nobody's perfect, including myself, of course. The whole time we were there, what would happen would be, if there would happen to be a mid-fiscal year problem with the budget and the need for a shrinking of the budget, the governor would issue an executive order. I wrote it or helped write it, and it would direct all the governor's cabinet and people, the departments under the governor in the executive branch. Not all of them are under the governor in the executive branch, thanks to our Constitution, which is very good, and that's thanks to Edwin Edwards. That would give them a directive to come back with recommendations to the governor, basically a smorgasbord that the governor could select from to achieve the reductions that were needed. And it would set a deadline. And when that deadline would be rapidly approaching, there would be a swarm of public records requests that all the agencies that had to submit budget information from a very solid journal or rag, and I say that affectionately, in Baton Rouge, and I won't name anybody or any organization. The public records request would be landing on desks all throughout Louisiana government, state government, and that those people had no defense, and I say that thinking of the people in Washington. They would have to give up that information. Well, then the newspaper would print the articles. The people would get to see what was going on and what the governor was going to have to pick from. The governor would make decisions. It was premature information, and perhaps it did cause confusion, but the people could handle it, okay? Those who were paying attention, and I must admit, there weren't but about 10 or 12 of us statewide.
They're all here today.
And half of them are here today, and the others are gone. But in any case, the public records requests were made, the information was given up, and everybody lived happily ever after. Okay, yeah, there was some articles written that were temporary, and that was the end of that. Well, now that doesn't have to happen anymore. We have a very, very big backslide on that point. It's not part of the deliberative process privilege. It's another crazy thing that this administration came up with, and it ought not be the case. Anyway, so we have that one. And look, I have squandered a lot of time thinking about this issue. So I can cover almost any issue, maybe not well, but I can cover almost any issue you can come up with on it. And so right now, I don't want to talk forever, Linda, and I've told Linda to rein me, and I'm fighting a cold, so I'm goofier than normal.
Well,
So,
well, I did want to ask you this one
Yeah.
question, Terry. Do you agree with Mike that it is a preferable thing to have some sort of tight statutory definition, or that otherwise the court is going to kind of pull out of thin air this concept of a deliberative process privilege?
Oh, absolutely. And if I could speak to that, we have in Louisiana law the deliberative process privilege, which I mentioned. That is in the statute, and the only place it's in statute, and it's only for the governor.
But it's so broad.
No. Well, yes, that one is, but it's only for the governor. The real problem in Louisiana is not that one. The problem in Louisiana is that in 2000, and that was a 2009 statutory change under the current governor. The real problem in Louisiana right now is what is happening in the agencies. In 2004, the Louisiana First Circuit Court of Appeal, we have district courts, Court of Appeals, and then we have the Supreme Court. All right. The Louisiana First Circuit is the jurisdiction in Baton Rouge, and it's the one where all the government administrative law cases tend to wind up. That court rendered a case in a fight between the legislative auditor and the Louisiana Public Service Commission, which is a separate constitutional body. It is in the executive branch, but essentially they're all elected separately. I think there are 5 of them statewide. They're not under the control of the governor. So they're a separate constitutional body. And in that squabble, the auditor lost big time because the First Circuit ruled that legislative auditor is in the legislative branch. The Public Service Commission is in the executive branch. So effectively, as I know y'all can all understand it, but I don't want to take up too much time here, so I'm going to cut to the chase. Essentially, the court ruled, and I didn't rule, let's just say the court said, hey, it is a deliberative process privilege, and it cited federal cases, the District of Columbia, and it quoted a paragraph, which I'm sure they regret, okay? And in that paragraph, they cited the 3 basic reasons for deliberative process privilege, and they basically told the auditor to take a walk. And they said that there is a deliberative process privilege. The Public Service Commission could assert it, and then they basically overturned the trial court. All right. Here's the problem with that case. All right. And this is written by a judge who was in law school with me at LSU, and he's a great jurist and a wonderful human being. He just made a mistake here. Okay. His pen got out of control. Okay. We call it in the law dicta. Okay. And if there is in the dictionary, Black's Law Dictionary, a photograph by any of the definitions, it should have a picture by the word dicta of the facade, this case heading, because this is dicta. Essentially, in ruling that the district court was wrong, the court said the procedure that had been followed by the auditor was wrong. It was unlawful, was the term. Instead of seeking a mandamus, they should have gone for a subpoena. That's important to us lawyers, and the rule of law that we follow in this country and state. And we are a rule of law in Louisiana, by the way. Not personality, as the person that was named earlier thought. But in this particular instance, since it's merely dicta, there is no rational basis for relying upon it. Nevertheless, we see state agencies in Louisiana choosing to follow dicta in a court case and assert a deliberative process privilege to protect public records from the public, and in doing so, ignore their oath of office and the state statutes which require them to give up that information. It's really outrageous. I think somebody else used that word.
Well, I was going to say, let's stop at this point in the time we have left and take questions from the audience.
Just one.
I'll take the opportunity to ask the first question, and you're right next, Mike. But you guys mentioned, or several of you mentioned, that it's better to have it laid out in statute than the constitutional separation or whatever. Can you point everybody to a state where the pre-decisional exception, the executive privilege, or the deliberative process is spelled out in statute where it's done well?
Yeah, there are several states. New Mexico. Washington actually has, they have the executive privilege, which we've been fighting over, which is not statutory, but it does have pre-decisional, or a pre-decisional exemption that's written very well. So it says It applies to intra-agency memos that are pre-decisional and that contain opinions or recommendations. So not facts, but opinions. And the case law has interpreted that exemption to also say, once the decision is made, once it's implemented, it's all public now. The idea being it shields the process during the process or the decision-making process, but after the decision is implemented or the policy is created, it goes into effect.
This is a question for Terry. Can you cite an example where, in your experience, that the executive privilege was correctly used, or I mean, how it helped not chill discussion with the governor? I mean, I'm a little skeptical of these claims that this is high pressure, and I mean, you know, we're not talking about the Cuban Missile Crisis here. I mean, we're talking about, I mean, when would have a deliberative, you know, affected a decision that you can think of?
Yeah, thank you for the question. Look, I share your skepticism to some extent, but let me say right now, whatever example I could give you is subject to the attorney-client privilege, which I have to live with the rest of my life. Yeah, well, I have been in many situations where, you know, post-Katrina, I'll give you an example, a generic example. Post-Katrina, there were life-saving issues that had to be dealt with by the governor very, very quickly. You essentially get into a brainstorming situation. What are the possibilities, and then what are the effective ends that could be achieved by different approaches? And in the process of having the discussion, things don't get said in the most perfect way. They're not necessarily meant that way. But I'm not going to argue that there is a broad need for this. But I'm just saying I've been in those situations and with multiple governors, actually 4. And occasionally that is very much, it's a situation where, for example, I can tell you I know I have given advice to one of the governors that I would not have given, or at least not when I gave it or exactly how I gave it. So it has a chilling effect on the frankness and the thoroughness of that advice, that is given by the key advisor. So in my opinion, I would rather have the freedom to just say what's on my mind in the way it comes out and not worry about how to dress it up when it's appropriate for that to happen. I know it doesn't answer your question, but that's how I feel.
Could I just give a counterpoint on that? And Terry and I agreed that we would disagree strongly on stage, even though we've become friends. The problem that we pointed out in our case in Washington is that while executive privilege might be useful, or deliberative process privilege might be useful, there are other exemptions that do exist in law that governors can avail themselves of. You mentioned one, attorney-client privilege. There are state security privileges that are often in state laws. And then, you know, of course, some states do have some kind of pre-decisional exemption in their law. The question you asked, though, is one that I think there's an opportunity here. And I came to this panel expecting to give Ken an idea for a project that we could work on. And that's this issue of evaluating the quality of advice that is given to governors that have deliberative process in their state or that don't have deliberative process in their state. Gerald Wetlaufer wrote a very good law review article back in the 90s that questioned this whole myth, or he called it a myth, the myth of executive privilege, I think is the title of the piece. And he said there's no empirical evidence that the quality of advice is different in states that don't protect this kind of discussion. I don't know exactly what we could do, but if we could find some way of evaluating that, and maybe finding a professor who could bring some empirical analysis to it, I think it would be a very useful thing for us in terms of fighting this back at a legislative level.
Can I respond? Because there are a couple points I'd like to make at this point. And I share the wisdom of your comment, of course. Two quick points, at least I hope it's quick. One is there's a sobering reality that you all need to face, and I'm not here to tell you what you need to do, but I'm going to say it that way right now because I'm in a hurry. The bottom line here is, let's take Louisiana as an example, whether you like it or not. All right. In Louisiana, we've never had the Louisiana Supreme Court face the issue of, is there an executive privilege? That's never had to be faced. Why? Because when we enacted the public records law back in the middle of last century, they put in Section 5, which was the blanket exemption I referred to you, and the one that I served under, not this new thing. And so the court's never dealt with it, hasn't had to. I did fight back on behalf of Governor Blanco, multiple attempts to repeal that statute. What I told the committee in 2006 was the following. I said, look, you know, nothing's perfect, but if you repeal this statute, here's what's going to happen. This is my prediction. I'm often wrong, but not all the time, fortunately. I tell it to my wife that I was advisor for 4 governors, so I must have gotten something right at some point, and that got me nowhere with them, so I don't think it'll probably carry the day with you either. But the fact of the matter is, if the legislature in 2006 had repealed Section 5, as the press advised or recommended to the legislature, here's what would have happened. Considering the fact that the Louisiana Supreme Court had already recognized privileges and immunities, kind of executive privilege mishmash for the legislative branch, and also had gratuitously found for itself, the judicial branch, an inherent powers exemption. Had there been no statute to protect the executive branch, what do you think would have happened when that issue would have been presented to the Louisiana Supreme Court? Okay, I could be wrong, but I'd be willing to put some real money down on this. They would have found some form of an executive privilege under the separation of powers argument. It's all over the country. As Linda says, it's really contagious at the federal level. I think the states have behaved a little bit better, generally speaking. But that's what they would have found. So you would have had some judicially created executive privilege that you would have had to deal with eventually. Now, that's one point. The other point I want to make, and I'll try to shut up, is we have to always remember and have this perspective, and that is, this is a country where the rule of law is supreme. It's really important. And it's also true in Louisiana, although you may not know about that part of Louisiana. Okay? And I commend Robert for all his jokes, but I take very seriously the fact that this is a great state. We have a great constitution. The people are great. The food is great. And most of the people here are very interested in open government and the rule of law. With regard to the rule of law is the following. Yes, in our Constitution, our state constitution, there is a very strong requirement that the documents be made, that the people be available to, have available the records and also be able to attend meetings of government, open meetings, public records. But also in the Constitution are a number of other rights, like privacy, association or assembly, the right to petition government, and then authorized by the Constitution are many other exemptions, Homeland Security, medical records, blah, blah, blah. All of those rights have to be balanced against the right of the access to documents. So whether you like it or not, that's a reality that we all have to deal with. And in some way, these executive privilege deliberate process things deal with some of those issues.
Well,
I'm done.
To Michael's point, I mean, they're already on the books. You don't need an executive privilege. They're already there.
Well, there's already Article 2 in the Constitution, and so the case has never been presented to the Louisiana Supreme Court. If you take away the statute, they will look at the Article 2. I mean, I'm just saying, you know.
Well, Terry, let me ask you a
reality.
yes or no question, either yes or no. If Louisiana or any state were to adopt a very, very narrow deliberative process privilege, where the information that could be kept confidential is very, very narrow, would the court accept that limitation, or do you think they would read into the Constitution a broader privilege for the executive than is what is specified in the statute?
Well, I'll answer it this way. One, you all may not be as aware of the following as we are here in Louisiana. We are a legislation-based state. We are not into the courts developing law for us. So in general, the court's going to defer to the legislature under our Constitution. But I don't think it would hesitate to smack the legislature if it cut off constitutional rights it believed existed. We've had a case that went down just recently on the minimum foundation formula in which the Louisiana Supreme Court just taught the legislature how to read the Constitution.
I have 2 points. The first point is, Terry, a lot of the things that you were just discussing are actually oral conversations that wouldn't be covered by the public records law. So, I mean, in the middle of Katrina, the executive council doesn't write a memo to the governor and says, hey, I think we need to invoke XYZ powers. He walks into the governor's office and says, holy crap, the levees just broke. We need to fix this problem. What do we do? None of that is covered by the public records law. So I think that this is kind of a solution without a problem. And so my question to Linda, can you give some of the folks in this room some more background on how Louisiana kind of was a little bit railroaded in 2009 when we thought we were opening up the governor's records, but in actuality, we created an exception that swallowed the rule?
Yes, what happened is that the Press Association, and I think yesterday we had some conversations about how sometimes the NFOIC and the Press Associations are not always on the same path in the legislature. The Press Association tried very, very hard to work with the Governor's Council to eliminate the blanket exception for the governor. At this stage of the game, the deliberative process exception was put into the recommended statute by the Governor's Council. The smaller newspapers in the state who make up a large part of the Press Association membership, they did not come out in favor of this. They took more of, the testimony was to the effect that, well, this isn't very good, but it's the best we can do. At least we got rid of the blanket exception. The major newspapers in the state that really deal with this stuff all the time really saw the problem and certainly pulled out of the support, or well, the kind of neutral position that the Press Association took and strenuously opposed this portion of the law. So there was that divergence of opinion there among the membership in the Press Association. I think that in looking back and now having seen the results of what they did, everybody who was rather neutral or cooperative on the point is regretful that this happened because we created a big mess. I guess my advice, if I'm in a position to give advice, would be if you are confronted with a statutory provision, if you don't already have one, for goodness sake, make it as narrow as you can. And I like the provision that says once a decision is made, the records become available. I was going to make the same point as Scott. A lot of this stuff is, you know, at the wink and the nod stage, like Robert mentioned. It's not reduced to writing. And I also seriously question whether people at certain level of government are all that averse to having their opinions known and made public, especially after the fact. And you know, just think about if you're dealing with, say the governor is going to make a recommendation on changing the open meetings provision. Suppose he's going to sponsor a bill, have a bill put in to do that. Well, I would argue that the people out there certainly need to know what the Press Association, the interested party, had to say about this. What the NFOIC had to say in their advice to the governor, what the Municipal Association had to say, what the School Board Association had to say. I just think if you have a broad exception like we have right now, all of that information would be unavailable. So be sure that you get. I would say you ought to be able to get consultants' recommendations and things of this nature before the fact, so that you can encourage public feedback and discussion on a proposed policy or a recommendation. I mean, it's too late after the horse is out the gate, so to speak.
We have about 5 more minutes for this panel, so I'm going to ask everybody to keep your questions as short as you can and responses so we can get as much dialogue as possible. So.
Hi, Joey Sennett from Oklahoma. Yeah, our governor created this much like in Washington, where we don't have it in statutes, not in the state constitution, it's not in common law. I just want to make a couple of comments. I wanted to thank Linda for using the term kudzu. I'm from down here. I'll have to explain it to Oklahomans what that means. But that's the fear, is that this is creeped down from the president, the U.S. president, down to governors, and then in 20 years we'll have this already established for state agency directors, and that'll all be way down to city council, you know, to mayors and the county commissioners. Everybody will be making these kind of claims that they have this chilling effect. In fact, I've heard that in every state I've worked at from city councils, why they have to have more executive sessions and they can't discuss things in public because it'll chill them. And the point I've been making in Oklahoma is the governor's making this claim for her cabinet, and these salaries are well over $100,000. And if these people are chilled, we're hiring the wrong people. I'll be glad to take one of those jobs and have it known. And the last thing is, I've also said I understand that this is an honest difference in opinion, but it's a difference in opinion about the role of the public in overseeing their government. And in Oklahoma, our Open Records Act and our Open Meeting Act state pretty clearly the public has an inherent right to know and be fully informed about their government so they can exercise their inherent political power. You can't do that if you don't know why they're making the decisions, if you only get it after the fact.
Yeah, just quickly in response, I think you're absolutely right. And it's not just that the public gets to know what the decision was. The public also gets the ability to evaluate the quality of the decision and the decision-making process. And I could give you story after story of decisions that were made that on the appearance of them, they look questionable. And I'm sure that there's no corruption issues. It's not that someone was trying to do something illegal or wrong, but the public doesn't get to see that, and more transparency would be better.
Sean Musgrave from Muckrock in Boston, and we help people file public records requests all across the country. And I wanted to echo what you said about the creep of this, and not just in terms of executive privilege, but deliberative process, as Linda was talking about. We're seeing this at local police departments where they're saying, we can't tell you what equipment we thought about buying because that would chill our equipment acquisition process. And so I do, in the brief minutes that we have left, want to ask your opinion on how do we fight that creep, and how do we combat that not just at the executive stage, but also at the deliberative process at individual agencies, and especially at the local level, where some of us are seeing that all the time, where it's not even established, but they're still exerting it.
Well, I would just say that I think this ought to be a priority for the state organizations. I think it's much more important than some of the bills that we spend an awful lot of energy on that may not be quite as significant in the long run as this is. I think this ought to be right at the top of the list, to have the most narrow possible statute limited to the fewest number of people.
This will have to be our last question.
Kent Flanagan from Tennessee. I'm just wondering, you're talking about creep. The creep has gone down to such a level that no one can ask for the governor's schedule, past schedule, as if there's anything left to decide about what he's decided on those trips wherever he may have taken them. We can't find out where he's gone, what business he's conducted, and if it was all for the state of Tennessee or some other private business.
Yeah, I mean, I think, obviously there are issues of security. I once asked for, in Washington, there are a lot of bodies of water, so there are ferries that go from peninsula to peninsula. And I once asked for the security camera videotape of a ferry because there was an incident where it crashed into its landing dock, and we wanted to find out what the response plan was, and so we asked for a number of documents, and we couldn't get that. They said national security. We're not going to give it to you because if you happen to be a terrorist, you might use that in a bad way. So there are sensitivities there, but certainly past schedule. I think there's less of a reason to protect that.
If I might, I agree with that comment, and I agree with your answer 99% of the time. Clearly, the public has a right to know what the governor is doing. You're paying the governor. The governor is doing the people's business most of the time. Most of the governors are anyway. But I will make this one observation. Okay, having been in the governor's office, you need to realize that there are security aspects of information that is assembled and available, in which would become available if there were no exemption. In the patterns of the security team, numbers, when they show up, how many vehicles, what kind of information they have, what kind of weapons they have, what kind of communications they have. I would argue that that kind of thing should never become available because the patterns can be pieced together by the bad guys. We have, believe it or not, there are some bad people in this state, alive. So for them, I would say the true security, and we could all sit down, Scott and I will sit down and try to negotiate what that would be. But in general, it's absurd to say that you can't be told what the governor did last week, or who he spoke to, what he did, in general. So I agree.
A spirited discussion and a great job by the panel. I knew that would be the case on both